Hi, I'm Karen Litz, president of the Network of Enlightened Women. I'm excited today to be joined by Carrie Severino. She's the president of the Judicial Crisis Network. She co-authored with Molly Hemingway the best-selling book, Justice on Trial, the Kavanaugh Confirmation and the Future of the Court. As an expert on the confirmation process, Carrie is extensively quoted in the media and regularly appears on television, including MSNBC, Fox, CNN, C-SPAN, and ABC's This Week. She was a law clerk for Supreme Court Justice Clarence Thomas and on the U.S. Court of Appeals for the D.C. Circuit, and is a graduate of the Harvard Law School, Duke University, and Michigan State University. So lots of degrees there, Carrie. We're excited to have you with us today as an expert on the confirmation process. Thank you so much for joining us.
Great to be here. Thanks, Karen.
Yes, well, Carrie, let's jump right in. In January, Justice Stephen Breyer announced he would be retiring from the court. Read about some of the pressure he was facing. Could you talk a little bit about that?
Yeah, that was something that I was very discouraged to see. You know, it's not surprising to me to have groups on the left who want to see a Supreme Court justice retire, particularly after kind of some of the softer arguments for Justice Ginsburg to retire. People did write a couple op-eds from, high profile people saying, strategically, it might make sense to retire now rather than wait to see who gets elected, whether Hillary Clinton gets elected or Trump gets elected. And Ginsburg decided not to retire. And obviously now we have Justice Barrett as a part result of that. So the left feels very burned by that. And it wasn't surprising to me that they wanted to see him to retire, but I thought the way they went about it was very inappropriate. I mean, this is a Supreme Court justice. This is someone who does have life tenure, and like it or not, it's their decision when they retire. And this is not a situation where, he was having trouble completing his work or he was getting too old. He was doing just fine. So the fact that they were then running billboards around DC. So this one group, Demand Justice, which is a liberal dark money group in the same sort of network of groups that also bankrolled the Biden campaign to the tune of hundreds of millions of dollars. They wanted to get rid of Biden so bad, they were running a billboard around DC that said retire Breyer, and explicitly saying it's time for a Black woman to replace him. And then after he did retire, my personal opinion is, if anything, that might have delayed his retirement. He might have considered retiring a year earlier. And it was just such an off-putting and politicizing way to view it. Justice Breyer understands the politics around this. He used to work on the Senate Judiciary Committee, but you know what? He doesn't want his seat to be a political football. And that's what they were really doing with it. And then unfortunately, when he did retire, they actually ran a piece saying it was shamed by your tweets. Justice Breyer retires, like to their followers, like he was reading. I'm not sure he even knows what Twitter is, but he definitely, I don't think it was because of being shamed by the tweets. I think this is something that he was able to come to that decision himself, and there should never be a public pressure campaign like that. Just it's gross. It's not, that is not treating the position with the respect that it's due.
Yeah, Carrie, is this a new phenomenon? Demand Justice seems to be very, outright in what it wants out of the Supreme Court. Is this a new approach to Supreme Court nominations?
Well, they have a very extreme approach. They really think that justices are there to provide them the policy results that they want to see. And this is that is an approach that they bring to the philosophy of how someone should be ruling in cases. And it's apparently an approach they also bring to how do we have justices filled and replaced as well. So they just, from their opinion, I guess, Justice Breyer didn't have anything else he could offer them when they had the possibility of having someone younger and more radical on the court. And so they didn't, their respect for him or the position didn't play a factor in that consideration. That's a shame.
Well, I found it fascinating, Carrie, that quickly after the news broke that he was going to retire, a number of groups on the left put out press releases with their demands for this nomination. One group I follow, the National Organization for Women, issued a statement that read, quote, "Now we'll hold him," referring to President Biden, "to his promise to appoint a Black woman to SCOTUS and ensure that she will hold intersectional feminist values." So I'm curious, again, is this a new approach we're seeing on the left?
Yeah, I think it's something that the left seems to be doing a whole lot more of now than they used to. But I think partly because they're also feeling a lot more frightened and desperate about the Supreme Court right now, precisely because we've made a lot of progress really in the last 30, 40 years on the Supreme Court in terms of finding judges whose approach to the law is one of looking at the actual text of the law, the text of the Constitution, rather than simply saying, as the left is doing, well, let's find someone who's going to agree with our position on various issues. So from that perspective, this is not a terribly different thing than what we've seen from the left before, because they do tend to be focused on, here's our issue. I just want someone who's going to vote my way on my issue on the court. And also the focus on kind of this interest group thing. If I want someone from my interest group here, and demand justice work this way as well. We have too many people who have worked in these type of fields. We need someone who, in their position, they said, they either wanted someone who'd worked directly in liberal activism. And so they put out a list of a lot of people who were potential nominees. This is before Biden had even been elected. And 3/4 of them weren't even judges. They wanted people who were straight up activists going right into the Supreme Court.
Interesting.
Or it was people who had a certain background in terms of, having worked as public defenders or having worked on a defense side, rather than, even if you work in defense at a big firm, they're like, oh no, that doesn't count. You can't work at a big law firm. So they really were trying to kind of check a lot of demographic boxes, apart, of course, from the obvious one, President Biden committing he was only going to appoint a Black woman to the court. And I think while a lot of people were happy to see the first Black woman justice, didn't feel comfortable with the idea that we're going to only consider people from a specific racial category and a specific sex. And I think that's something that is unusual and harkens back to an era that we don't want to really go back to, right? I mean, last time we were saying, I'm only going to consider a certain sex for government positions. We're talking like Civil War here. We don't want to go back there. So or not a certain sex, a certain race, but a certain sex too. I think we should be looking at all of the candidates. And while that might be a factor, I don't think that ever should be the determining factor that says someone doesn't even get considered for a position. Now, obviously, it seems like the groups that were on the farthest left and the ones that were the best funded, really, the dark money groups did get the nominee they wanted, because there were several potential women being spoken of that the president might have chosen, and he seems to have chosen, by all intents and purposes, the most liberal and the most the one who was being demanded by those activist groups and the dark money groups on the left.
Yes, let's turn to his nominee. So President Biden announced his nominee, Judge Ketanji Brown Jackson. So talk to us about her credentials. Are the leftist groups happy with her nomination? It sounds like you're saying they are. And where are we in this process now?
Yeah. So she was basically exactly out of central casting for them. She was the person that was on the demand justice short list, again, before the president even was the nominee, let alone elected. And there was a recent letter that was sent, public letter sent to the president from a bunch of these groups, many of whom kind of trace back to the same dark money umbrella groups here that said, we want someone with this experience. And if you looked closely, there was only one potential.
There's only one person, right?
So it was thinly veiled, saying this is the one nominee we want. They got her. She's someone who on a positive note, she at least does have experience as a judge, unlike some of the people that people would have liked to see. So that's good. But there are a lot of there's a lot of concerns I still have, despite having years of experience on the district court and now maybe a little less than a year on the appellate court. She's still, there's still a lot of concerns about what is her actual judicial philosophy. So when she was being nominated for the DC circuit in the last year, she had a Judiciary Committee hearing. And one of the questions she was asked is, there's this theory of the living Constitution where you get to kind of breathe into the Constitution, the direction you think it's going. It's not just the language, it's kind of where it's going. And how do you feel about that? Is this how you approach it? And she basically said, I haven't really considered clearly an approach to how I would deal with constitutional cases. I haven't had to decide a lot of constitutional cases as a district court judge. And so I don't really have an approach to this. Well, oh my God. That's crazy. This is someone who's now on the second highest court in the land and doesn't really know how she wants to interpret the Constitution. Wow. Before you put her on the Supreme Court, please let's figure out at least how she would interpret our founding document, which is a main part of her job on that. So that scares me. Either she hasn't thought through this enough to really be qualified for the position, or she's trying to not talk about her actual position. And that's troubling as well, especially when you're, of course, speaking under oath to the Senate Judiciary Committee. So I think that's something we really need to look into much more closely. Her record on the district at the district level, we don't have a lot of her record at the appellate level because she's been there such a short time. Her record at the district court level is one of having an extremely high rate of reversal. Now, that doesn't by itself necessarily, you could have just, if you're a conservative judge in a very liberal circuit, you might also have a really high rate of reversal. But some of her reversals are particularly troubling because of what they indicate. She has several cases, as is common in the DC circuit, reviewing regulations by the administration. In this case, it was the Trump administration. And in cases where she was overturning these regulations, where she didn't even have the authority to do so. So, for example, one, a public sector union case where she overturned it, and the panel, including a liberal justice, a liberal judge, overturned her and said, reversed that and said, actually, you don't have the authority to the court. This court doesn't even have the authority to make this decision. Another one, an immigration case, same thing. 2 of the 3 judges in that panel were some of the most liberal judges on that court. They also said, you don't have jurisdiction here. This is something the Department of Homeland Security has the unique jurisdiction to determine. It had to do with illegal immigration. She spent a lot of that opinion waxing poetic about the benefits of illegal immigration. And then she made a decision that really was committed to the administration's authority, not a judicial authority. So they ended up reversing her, and that decision went back into effect. In another case, I was concerned because she used very intemperate language about the president, said the president didn't seem to know if he was a president or a king. I think you can rule that they don't have authority to do a certain thing, but I think you have to be careful in terms of how you talk about a politician and not becoming very political yourself as a judge. So some of that record concerns me in terms of her background. Now, she'll have a Judiciary Committee hearing that hopefully we'll get a chance to explore that. We don't have that scheduled yet, but I anticipate they're going to try to move it as quickly as they can. It's a challenge. They want to get it done before the court breaks for the Easter recess, which will be in the beginning of April rather. And but it's also challenging because there's a lot of documentation she's going to have to get together in terms of her background and some of the speeches she's given, all sorts of stuff for the vetting process to go forward, as well as she's going to have time to prepare herself. And I think, I don't know if everyone can appreciate, and remember Amy Coney Barrett's confirmation process where she held up the pad of paper that she had been taking notes on and it was empty, right? So that she was able to do this all, no notes. That is
it's such a moment, Carrie.
Oh my gosh, what a moment. But that is like beyond unusual. That is, I could not imagine trying to go into that with the level of prep she had to do that. The idea that even Justice Kavanaugh, who was incredibly, he was very on top of his game going into this. He spent just dozens of hours preparing, being up on every single possible Supreme Court case you could ask about. Ask all the people who watch that process. This is a very, very intensive process. So Judge Jackson has got to be, absolutely up to her neck in stuff that she's trying to prepare. So that's another, pressure on when they can schedule this hearing. They're going to want to schedule as fast as possible, but if they schedule it too soon, she's not going to have time to be prepared for the level of discussion that normally is expected at those hearings. And I'm hoping we're not going to then just see another, I don't really have an opinion on that, because that doesn't really cut it for me at a Supreme Court level.
Well, Carrie, at the beginning of these last comments, you mentioned judicial philosophy, which is so important. I know we spend lots of time in law school talking about. For our members who are college students, could you talk a little bit about the type of judicial philosophy you like to see in Supreme Court nominees?
Yeah, so I think the judicial philosophy, and I think this is something that if you ask most Americans, they probably would agree with. The way you should approach the Constitution and reading the Constitution and the law is that the words themselves actually have meaning, and they mean what they say. Now that sounds kind of strange, but they're not all judicial philosophies take the words in the text that seriously. So I think because we have a representative system, right, and our Constitution was ratified by the American people, by in each state, and then also each time there's been an amendment that has to have been ratified by the people through their elected representatives, in some cases through the states, but it has to go through the representative democratic process. This isn't just something that some, 1 or 2 people could say, hey, I think we should amend the Constitution, done. It has to be something that has overwhelming support, right? So the words that they chose have been chosen carefully and for a reason. And they meant something to the people who ratified it. If we don't give those words the same meaning that they meant to the people who ratified them, then we're basically saying, we can make this up again as we go. And whoever gets to define the words gets to essentially re-ratify or recreate a new amendment to the Constitution. So we have to be careful that we're looking at the words as they were meant to the people who passed them at the time. And that sometimes that can be complicated, but we don't mean we have to do mind reading. You can just go back and look and see, some silly things that come up in treaties or in contracts are, does the term fish mean really just fish, or does it also include things that are octopuses, which are not technically fish from a biological standpoint, but maybe legally that was considered that was something you would go fishing for. So you can also, if you have a contract where you can take fish, you could also take octopus. Can you take whales? Well, they're mammals. I don't know. So you'd have to look into, when they signed that, did they understand that to mean, fish? Did they understand it to mean all sea creatures? What did they mean? We have to kind of do the same thing when we're looking at the Constitution. So if we say, the right to bear arms, what did those mean? What did that mean to the people who passed it? If we talked about the right to free speech, they actually had a real sense of what that meant at the time. And so we have to look and say, when that was added to the Constitution, what did that mean to the people who voted that in? Or statutes, the same thing. What did that mean to the Congress that passed it? So we know we're actually giving. And if we think we disagree, maybe today we'd rather mean something different. Maybe we want to be more particular about biological fish versus octopuses. I don't know. Then we can go back, and that's what our amendment process is for the Constitution, and that's what our legislation process is for law. So if they screw up a law, or a law is out of date, or it had consequences we didn't anticipate, then that's when we go back and change it, but we have to change it through the elected process. There are other judges who basically have taken an approach and said, well, we can, in the case of a statute, look at the overall purpose. So if the Clean Air Act says we want to have clean air, but then it also has a lot of details about how that's going to work out, that Congress fought over and debated over and had a lot of discussion before they could get a majority vote, can you then just hand it to a judge and the judge says, well, we want clean air. Let's just do whatever makes clean air. That undermines our whole process, where we had people we elected who said, yeah, but clean air is going to mean this. This is how we're going to balance it with the other, property interests, or the interest of making sure that the government can only afford to do so much of this, or, whatever different things, or this is how clean is clean. Do we everyone need ozone purified clean air, or do we need, so that's not something that our system committed to judges. It committed it to the legislative process, or it committed it to the amendment process. So if we have someone who comes up and says, well, I think the Constitution just evolves with time, then the question becomes, well, how does it evolve? Where does it evolve? How am I supposed to know then what the Constitution says? And unfortunately, I think that often boils down to, well, you have to just ask the justices of the Supreme Court. So what they're saying is 5 out of 9 unelected justices can change the content of the law or the Constitution. And that's something that's really disturbing to me, because that's not how our Constitution designed it. It didn't say, we'll just write a few words down, but we'll create this body that can then just make up whatever they want from here on out. That wasn't at all what the Constitutional Convention was about. And it doesn't respect our representative government to say we're going to have just these justices who are doing it that way. So I think if we have justices who are limiting themselves to the text, then the best part of this is almost it takes it out of the political process. Then I don't have to worry about, gosh, do these justices want to evolve the Constitution in a way that I think is going to be good for the country? Doesn't matter, because if they're just reading the text of the laws, then I can worry about electing my senator and my members of Congress who are going to write the laws that I want. I can worry about electing the president who's going to write the laws and help affect the regulations that I want, and not have to make my judges into the politicians then, especially because they're politicians that it's uniquely unrepresentative. They're not supposed to be elected on, and they never go up for re-election. So you can't ever keep them accountable if they kind of went crazy and went in a different direction.
Judicial philosophy is definitely something I will be paying attention to during this hearing, and I hope our students do as well. Could you talk a little bit about what else people maybe should pay attention to during the hearings, and how this compares to Justice Kavanaugh's confirmation process?
Yeah, well, one thing I think will be a breath of fresh air after the last few processes is I can tell you, at least from my perspective, and I think any GOP member of the Senate is going to say this as well, there will not be a big, Christine Blasey Ford scandal moment. There's not going to be a let's dig and find some, something that she did in high school that we can blow up into something and block this nominee. There's not going to be a smear campaign. So I think the good news is I don't think we have a soap opera coming up. I think what we should have is something that probably is a lot more tedious maybe, but I think we need something more like a documentary on judicial philosophy. We should be having a real discussion of that kind of issue and digging into the real meat of, okay, what would you do on the Supreme Court? We can expect from the hearing, normally the first day is a lot of people introducing the nominee and her giving an opening statement. And then you're going to probably have a couple days where she's going to be questioned by members of the committee, and they'll take turns in, maybe 5-minute increments or 10-minute increments. It kind of depends on Senator Durbin, who's running the committee, how he does that. But they'll all take turns, and they can ask her questions, about anything that she's made a decision on in the past. Her in her role as a judge, that's going to all be fair game. So if there's decisions that they're concerned about, so like some of the ones I mentioned, those will be delved into. And of course, her judicial philosophy, absolutely fair game, right? One of the things that's always a sticking issue is asking about a decision that it might be coming up before the court. So if you ask them, how do you feel about, the Dobbs case? No way in the world she's going to answer that. Any decision that's likely to come up before the Supreme Court, any nominee is going to say, I can't make a comment on it because I can't commit to how I would decide a future case. But you can ask them about the past cases that they talked about, and also these broad principles of how do you approach the Constitution. So you're not going to be able, she's not going to say, well, here's what I think these specific contours of the First Amendment are. But if she decided a case on it, she can explain her reasoning. And if you want to talk about broader ideas, like how do you think the words of the Constitution mean what they say? Do you think they mean what they meant in 1789, or do you think they just mean what we think they mean in 2022? All of that will be fair game. And then there's often generally a final day where there's going to be people on both sides, from invited by both senators on both sides of the aisle to talk about the judge. Might be people she'd worked with, might be people that know her in some professional capacity. Generally, in the last few years, what we saw, and I think was not a benefit to the process necessarily, was a lot of nominees that were just talking about different issue areas. So for example, with Justice Barrett's confirmation, there were some people saying, well, I get healthcare because of something that happened with Obamacare, and therefore you're going to overturn Obamacare, which of course turned out not to be true. But they said, and therefore, you should vote against Judge Amy Coney Barrett. So people who are talking about different issue areas, I think that's something I hope we don't see a ton of it, but that's something we often do see, and that ends up just turning into I think a less valuable in terms of talking about the nominee herself. If when we have those witnesses, I hope they're talking about the nominee's actual judicial record and their approach to the law.
Well, thank you, Carrie. This is very helpful, giving us some quick insight into what's going on with the Supreme Court nomination. Could you end by sharing where people can follow you on social media?
Yeah, I'm at JCN Severino on Twitter. We have a website, judicialnetwork.com. And you can also see me blogging at Bench Memos at National Review Online.
Wonderful. Thanks so much, Carrie.
Thanks.